Good evening. Welcome to Newsfeed PM, the Saturday night edition with me, Katlego Msomi. It's always a pleasure to have you with us. Let's start off with this. South African lawmakers have made changes to the proposed employment equity targets, which were released last year. The changes published this week include doing away with specific targets for African, coloured, Indian and white workers. To help us understand what these changes mean and if they bring any progress to employment equity in the country, we are now joined by Professor Hugo Pienaar, the Director of Employment Law Practice at Cliff Dekkerhoff-Meyer. Thank you so much for joining us this evening, Prof, so late into the evening. Let's start off by just explaining what inspired the republished regulation.
Yes, so what you may recall is that in 2023, the Minister was granted a discretion to set numerical targets for certain national sectors. And they published a draft regulation during May, which was heavily criticized and fortunately withdrawn. And that has resulted, after many submissions by many lawyers and academics, he reissued this new regulation. So that's by way of background, and that's why we have a new regulation now published. And this time we have 90 days to comment, as opposed to the previous 30 days for comment.
So, Prof,
So that's part of this new debate.
Sure. Let's start, Prof, possibly by just unpacking the sector targets and how to interpret and apply them correctly. I mean, in the previous targets, it was stated that top management of a national manufacturing company has to have 35% of Africans, 4% of coloureds and 1% of Indians, which tallies to 40%. But the new target simply says 40% of top management must come from designated groups, which are the groups that I've just mentioned, being the same three, giving the difference now is that the ratio of African, coloured and Indian is not stipulated. What impact would this have, Prof?
It is critical because it is done away, as you correctly stated, Katlego, with that distinction between the designated racial groups. And that is critical. So what you will now have, if I can just take us one step back, is that they will consider these comments for which we're going to submit within the 90 days, and then new regulations will be issued, or maybe an invite for further. What is important, what will happen then, is that there will then be an assessment of compliance by employers, and that will be enforced tenaciously. And what we've seen lately in terms of inspectors visiting, you'll have much more of an enforcement. And then the court will ultimately, when there's assessment of compliance, be entitled to impose penalties. So what does that mean for employers? It means that you must prepare your employment equity plans if you're going to court, and you will, inter alia, as part of your assessment of compliance, keep a detailed audit trail of what you've put into place. Because what will happen is, if this is going to be an assessment, the court will consider these compliance and whether there's a reasonable or justifiable non-compliance, and hence that's where we're going. So coming back then to now, the employer is faced, there's now different targets, and as you correctly said, there's just simple target set, and per category the difference, no racial discrimination, simply a difference between the categories. And that is male, female in terms of that, and then of course people with disabilities, but no difference between the different racial groups. So that will make it more difficult for employers, because in the previous code, or the previous draft regulation, you had to categorize not only in terms of national stats, but also in terms of provincial stats. So it was much more complicated. This time, simplified in that sense, but also simply, again, the 18 sectors and lower targets generally set, as we've seen before. I looked at the targets briefly, and of course the sectors it starts with from agricultural and all of those, including mining and the like. The lowest one that I could pick up in terms of targets to be achieved within the next 5 years would be 20% male, 15% for females, and that's quite low. And of course the highest, let me just see if my notes, if I could keep that, 50% and 40% respectively male and female in that particular sector, which is a more admin sector. So that is how it will impact. You will have to revisit the new targets once it's regulated, because at the end of the period, this will now be regulated, and you will have to comply in terms of those targets. So you will have your current employment equity plan for those high-skilled employees up to management, and you'll actually have to revise that, because it will effectively be substituted by these new targets to be set.
Speaking of those low numbers, Prof, and specifically honing into gender, how do these numbers influence the gender parity in the workplace? I mean, you are saying that they are relatively low, especially for females. Are we not going to be making any inroads in getting more females participating, especially in higher levels of top management?
If you look at the progress we've made inter alia with regard to females, it's actually sad to see how slow that was. Now, if you compare it internationally, by way of one example, in 1985, they introduced affirmative action legislation in Australia just for females. By the end of the century, 15 years later, and even more recently, they've again looked at those targets. And again, the progress was slow despite that legislation. And that's sadly still an international trend. At the top boardroom levels, we don't see enough females in that category. And we're following the same slow trend in terms of transforming boardrooms and the like. Of course, there is the history that certain categories of employees, and without job profiling or stereotyping, certain categories of employees attract less females than males, and you'll typically see it in the target set. For instance, in the motor repair industry, and there you will have lower targets. Interesting, in the truck industry, I think it's 50 and 40. And we've seen huge progress being made, for instance, in getting female truck drivers in, and people are doing exceptionally good in terms of that. But of course, progress from there on to management, etc., will continue, sadly, to be slow.
Prof, you made mention earlier on about the assessment of compliance as well as enforcement. If a company cannot achieve these EE targets, what would be the consequences? And can they appeal to say or state whatever reasons that they can in specifying why they can't reach these targets?
Yeah. Ordinarily, there's a non-compliance order issued, and that's after assessment, etc. And in that assessment, you'll have an opportunity to make representations. There may or may not be an appeal. And then the matter will ultimately be adjudicated by the Labour Court. Now, the good news for employers is that there's not a punitive approach by the court, because it's simply, have you applied reasonable and justifiable reasons, and have you set such for non-compliance? And as I've said, not a punitive approach. But when we look at the assessment of compliance, this is important in terms of what has happened here as opposed to the previous code, is there are a few factors specifically listed here, which was there in the first act when it was published and has since removed in the section 42, but it's backed by implication. It says, we look at the inherent requirements of the job. We look at pool of suitably qualified people. If you don't have female, let's say, black engineers, although as you indicated, that distinction has been drawn, but if you don't have sufficient or enough female black engineers, mechanical or otherwise, then the progress there would be slow. And that's the reality. But what has been specifically mentioned now is the pool of suitably qualified people. And then, of course, you will recall that this provision, of course, only applies to employers where you have 50 or more employees. But you could just consider the typical sort of family business. And it says here, rate of turnover and natural attrition at the workplace. Now, typical family businesses, that is slower than you would have in the normal commercial enterprise. What is also important, and that is criteria you can consider apart from others in setting up your plan, but and of course your justifications. And in terms of justification, again, there is issues such as insufficient recruitment opportunity, and then some others. But the important one, I thought, was the impact on business economic circumstances. And in terms of what we proposed and submissions we've made, we've previously said employers are often operating on a marginal level. Ideally speaking, in an ideal affirmative action scenario, you want mentorships, you want money to be spent on that. And sometimes employers are simply trying to survive and keep the doors open and say, well, job security is the most important focus of this business. And it's there now. It says you must consider the impact on the business economic circumstances. So I think that's a reality that employers are dealing with on a daily basis in the country. And it doesn't say you mustn't affirm. We all embrace the principle of affirmative action, but we must marry and find a balance of all those factors that may ultimately impact on what may or may not constitute justifiable compliance. And of course, what is more interesting of the lot, and I'm jumping potentially the gun here in my interview, but which is quite, and it was there by way of implication, it's there in terms of international law, it's there in terms of our law, but it now says no employment termination of any kind may be affected as a consequence of affirmative action. And what that simply says is that I can't take out a non-designated person, i.e. a white male, and simply to achieve affirmative action, replace that person with somebody in a designated group. Now, that has always been the case, but it caused huge uncertainty in the market, certain comments made politically and otherwise, and that has been quite clear in terms of this provision under 4.7 of this regulation. So I thought that was Prof, significant.
Of course, it's very significant. And on that point, Prof, would one be incorrect in interpreting this republished regulation by saying that these proposed targets no longer give set preference for previously disadvantaged African natives of the country?
First, important is to note that it's just applicable to the higher levels. So the lower levels, you still have the same distinction in terms of racial groups. My concern with the way that they formulated it now, without recognition of the specific designated groups, is it may create an opportunity which shouldn't be, and more importantly, it may even be viewed by some people as unconstitutional, because the Act is quite clear, and you can't, by way of argument now, say something that's beyond the Act or not provided for in the Act, because the regulation is always subject to the provisions of the Act. The Act is quite clear. The three categories that you must affirm, the one is black people, and that's the three different categories, African, colored, and Indian. And there would certainly be an argument, and people will make that argument and ask on what basis do we now take that distinction away in terms of the regulation, which is subject to the provisions of the Act. And then ultimately, we have Section 9 of the Constitution, which is the highest court of the land, and which provides for affirmative action. We're a member of the International Labour Organization. We've ratified those conventions, and we're bound by that. And even that provides for affirmative action. I'm using the term loosely. So there's going to be a huge debate exactly on the point you've raised, Katlego. And I can't wait to see how that will turn out. And it may be that the minister revisits this and say that I now have a better indication, and I'm going to, as a final round, issue another set of regulations, which may bring us back to the first one. But of course, it is complicated, and this code is much more employer or interpret friendly in the sense that it gives us clearer guidance as to what is expected. The previous one was just caused chaos.
All right, Prof, thank you so much for those inputs. Certainly is going to be one to look out for, and for the inputs that will be made across industries with regards to the EE targets. Thank you so much for joining us this evening. That was Professor Hugo Pienaar, the Director of Employment Law Practice at Cliff Decker Hofmeyr. Well, let's go for a quick ad break. We'll be back with more news after this.